Hello and welcome to Working Wise, a podcast created and produced by K&L Gates. Each episode is designed to provide labor and employment updates and compliance tips to lawyers and HR professionals. We hope you enjoy this podcast.
Welcome to K&L Gates Working Wise podcast series. My name is Greg Lewis, and I am an associate in the firm's Los Angeles office. I practice both in the firm's complex commercial disputes and litigation practice area and in its labor, employment, and workplace safety practice area. I am also part of the California team of our firm's global COVID-19 task force, advising corporations and other businesses on how to respond effectively to the social and economic disruption caused by COVID-19, or, as is more commonly known, the coronavirus. COVID-19 is a global health emergency, a pandemic imperiling the lives of citizens around the world. Globally, as of the recording of this podcast, there are 468,127 confirmed cases of the virus, which has taken over 21,180 lives. Here in the United States, the most recent statistics indicate that there are over 65,652 confirmed cases of the coronavirus, and 931 people have died from the virus. With the rapid spread of the disease, states and local jurisdictions, including counties and cities, have begun to enact shelter-in-place orders, stay-at-home orders, and other measures restricting their residents' movements in efforts to flatten the curve and curb the spread of this virus. These orders often also contain restrictions on businesses, including directing certain businesses to close. In light of these developments, businesses have been examining their operations to determine how best to weather this storm. Today, I will be discussing various scenarios businesses have been contemplating for operating with reduced workforces, as well as what obligations arise if they have to reduce part or all of their employees on a temporary or permanent basis. The first scenario I will be discussing involves wage reductions. For employees who are subject to the overtime provisions of the Fair Labor Standards Act, or the FLSA, these employees are commonly referred to as non-exempt employees. The FLSA requires that all non-exempt employees receive at least the applicable federal minimum wage for all hours worked. In a week in which employees work overtime, they must receive their regular rate of pay and overtime pay at a rate not less than 1.5 times the regular rate of pay for all overtime hours. The FLSA does not preclude an employer from prospectively lowering an employee's hourly rate, provided the rate paid is at least the minimum wage, or from reducing the number of hours the employee is scheduled to work. For employees who are exempt from the overtime pay requirements of the FLSA, these employees are commonly referred to as exempt employees. An employer is not prohibited from prospectively reducing the predetermined salary amount to be paid regularly to an exempt employee during a business or economic slowdown, provided that this change is bona fide and not used as a device to evade the salary basis requirements. Such a predetermined regular salary reduction, not related to the quantity or quality of work performed, will not result in the loss of the exemption, as long as the employee still receives on a salary basis of at least $684 per week, which equals $35,568 per year. On the other hand, deductions from predetermined pay occasioned by day-to-day or week-to-week determinations of the operating requirements of the business constitute impermissible deductions from the predetermined salary and would result in the loss of the exemption. The difference is that in the first instance, it involves a prospective reduction in the predetermined pay to reflect the long-term business needs, rather than a short-term, day-to-day, or week-to-week deduction from the fixed salary for absences from scheduled work, occasioned by the employer or its business operations. Employers who contemplate wage reductions should pay careful attention to state law. For example, many states require employees to receive a higher minimum wage than what is required under federal law. Additionally, in the event any prospective changes are made to an employee's wages, under many states' laws, the employee must be notified in writing in advance of the change. An employer should consult with an attorney as soon as possible prior to making any wage adjustments to make sure they are in accordance with federal law and any applicable state laws. The second scenario I'll be discussing involves hour reductions. There are 3 ways employers commonly reduce the hours of their employees: furloughs, temporary layoffs, and permanent layoffs. I'll be speaking about these topics at a high level because different states define these terms in different ways. Again, please consult an attorney to make sure that if your business does reduce hours, it does so in compliance with federal and state laws. So first, I'm going to discuss furloughs. When an employer furloughs its employees, it requires them to work fewer hours or to take a certain amount of unpaid time off. For example, an employer may choose to furlough its non-exempt employees 1 day a week for the remainder of the year and pay them for only 32 hours instead of their normal 40 hours each week. Since unemployment benefits are determined on a weekly basis, full-time workers whose hours of work are reduced by 1 workday each week usually will not be eligible for partial unemployment benefits because they earn too much in the week to be eligible. That being said, many states are relaxing requirements so that a reduction in hours may be a basis for recovering unemployment. Another method of furlough is to require specified employees to take an unpaid leave, for example, 6 weeks. If you do this, employers should be particularly careful with exempt employees, ensuring they take the entire week off work. If an exempt employee works a partial week, under the salary basis test under the FLSA, the company has to pay the employee the full salary week. A furlough that encompasses a full work week is one way to accomplish this because the FLSA states that exempt employees do not have to be paid for any week in which they perform no work. Whichever method is chosen, however, a furlough keeps the employees on the payroll. By contrast, a layoff is a separation from payroll when there is not enough work for the employee to perform. A layoff can be temporary or permanent. A temporary layoff happens if the employer advises that it believes that the condition causing the layoff will change and that it intends to recall the person when circumstances change and work again becomes available. With a permanent layoff, by contrast, the employer can still advise the employee that the employee is eligible for rehire if circumstances change. The difference between the two: one, when circumstances change, temporary layoff; if circumstances change, permanent layoff. In each circumstance, however, employees are typically able to collect unemployment benefits while on an unpaid layoff, temporary or permanent, or a furlough. And frequently, an employer will allow employees to maintain benefit coverage for a defined period of time as an incentive to remain available for recall for both furloughs and temporary layoffs. Now, we're going to put a pin in that benefits discussion for now and return to it later. First, however, an employer should know that certain hour reductions can trigger obligations to notify employees of the hour reductions. These obligations arise under what is called the Worker Adjustment Retraining Notification Act, or the WARN Act. There is a federal version, and some states have also adopted their own mini WARN Acts that impose additional notice obligations. I will be concentrating on the federal WARN Act. In most circumstances, when we are discussing topics, we ask the 5 W's: who, what, when, where, and why. For the WARN Act discussion, we're going to ask a little bit different variation of those questions. Who, when, and what. Who must provide notice? Who must receive notice? When are notice obligations triggered? By when must notice be received? And what must be in the notice? So first, who must provide notice? The Federal WARN Act does not cover all employers who reduce hours of their employees. There are 2 ways an employer may qualify as having to provide notice under the Federal WARN Act. If an employer qualifies under either of the 2 methods, the Federal WARN Act is applicable. The first way an employer can qualify is if the employer has 100 employees. Employees who have worked less than 6 months in the last 12 months and employees who work fewer than 20 hours per week do not count toward this threshold number of 100 employees. The second way an employer can qualify is if the employer has at least 100 employees and the total number of hours worked by full-time and part-time employees exceeds 4,000 hours exclusive of overtime hours. Next question, who must receive notice? Well, under the Federal WARN Act, the employer is not required to notify all of its employees of the hours reduction. It needs to notify only the affected employees. Affected employees are those that the employer should reasonably foresee suffering an employment loss as a result of the action, which the WARN Act views as either a plant closing or mass layoff, depending on the circumstances. Both of those terms have definitions that we'll get to in a moment. Both full-time and part-time affected employees must receive notice. The Federal WARN Act also requires that notice be given to the state disclosed workers unit where the plant closing or mass layoff occurs. Our next question, when are notice obligations triggered? Notice obligations are triggered as a result of a plant closing or a mass layoff, and these terms have specific definitions under the Federal WARN Act. The Federal WARN Act defines a plant closing to mean the permanent or temporary shutdown of a single site of employment or one or more facilities or operating units within a single site of employment if the shutdown results in an employment loss during any 30-day period at the single site of employment for 50 or more employees, excluding any part-time employees. A plant closing also occurs when an employer closes an operating unit that has fewer than 50 workers, but that closing also involves the layoff of enough other workers to make the total number of layoffs 50 or more. The Federal WARN Act defines a mass layoff to mean a reduction in force, which first is not the result of a plant closing, and second, results in an employment loss at the single site of employment during any 30-day period for, there are two conditions here, one, at least 33% of the active employees, excluding part-time employees, and second condition, at least 50 employees, excluding part-time employees. If the layoff involves 500 or more employees, then notice is required in all cases, even if the affected employees constitute less than 33% of the workforce. Additionally, the Federal WARN Act defines employment loss to include a layoff exceeding 6 months, a reduction in work hours of more than 50% during each month of a 6-month period, and any other employment termination other than for cause, a voluntary departure, or retirement. Now, I know there were a lot of numbers in there, but one number not to overlook is the number of days. Here's why. While the Federal WARN Act specifically concerns itself with terminations that occur over a 30-day period, an employer must also monitor terminations over 90 days as well, because an employer cannot seek to escape the Federal WARN Act's requirements by staggering smaller layoffs over a 90-day period. Here's a relevant example from the Department of Labor's fact sheet on the Federal WARN Act. If the number of employment losses that occur during a 30-day period fails to meet the threshold requirements of a plant closing or mass layoff, but the number of employment losses for 2 or more groups of workers, each of which is less than the minimum number needed to trigger notice, reaches the threshold level during any 90-day period, then the employer must give notice under the Federal WARN Act. So now that we've talked about the number of days, let's talk about those other numbers, the number of employees required to trigger Federal WARN Act notification obligations. There are 4 groups of employees who do not count toward the threshold levels. These threshold levels being 50 or more employees and, for mass layoffs, 33% of the total workforce. First, part-time employees are not included within the 50 or more employee threshold for plant closings or mass layoffs, or the 33% of the total workforce threshold for mass layoffs. Second, if an employee is offered a transfer to another location that is within a reasonable commuting distance, the layoff is part of a relocation or consolidation of the employer's business, and the transfer involves no more than a 6-month break in employment, the employee is not counted toward the total. Third, if an employee actually accepts an offer to relocate within 30 days of the offer or the layoff, whichever is the later event, that employee also does not count toward the total, regardless of whether the new commute would be deemed reasonable. Fourth, an employee is not terminated for the purposes of the Federal WARN Act if the employee is terminated for cause, voluntarily separates, or retires. Question number 4, by when must notice be received? Well, the employer must ensure that the recipients of the notice receive the notice 60 days before the layoff. Plans for providing notice should be made with an eye toward this deadline. Mailing the notice 61 days before the layoff would generally not be adequate under the Federal WARN Act because the recipients will not receive the notice in time. And so that begs the question, what must be in this notice? That final question. The Federal WARN Act precisely establishes the content employers need to include in a notice to affected employees. Notice to the employees of the layoff must include, at a minimum, the following 6 things. Number 1, the name and address of the site where the mass layoff or plant closing will occur. Number 2, a statement as to whether the layoff is intended to be permanent or temporary. Number 3, the expected date that the layoff will commence. Number 4, the expected date that the individual employee will be terminated. Number 5, an indication whether bumping rights exist. And number 6, the name and telephone number of the company representative to contact for further information on the layoff. The Federal WARN Act does not, however, impose any specific requirements as to what form of delivery this specific content should take. Mail that arrives before the 60-day mark is acceptable. Sending the notice via first-class mail is also acceptable. An employer could also elect personal delivery with the option of requiring the employee to return to signed receipt. There's one exception to the Federal WARN Act's looseness toward the form of notice. While an employer could provide the notice as a separate document accompanying a paycheck or pay statement, merely adding the notice information to the regular pre-printed information that accompanies that paycheck or pay statement will not provide proper notice under the Federal WARN Act. So we've now finished those 5 questions in our discussion of the Federal WARN Act. And you may be thinking to yourself, however, wait, we've got 2 who's and 2 whens, but only 1 what? And I have lots more what's to have answered. For example, what if there is an emergency like COVID-19? What if we didn't foresee this pandemic? What about those mini WARN Acts you talked about that some states have enacted? What states have mini WARN Acts? Well, exemption to the WARN Act's notice requirements vary widely under state and federal law. The Federal WARN Act, for example, has 3 exceptions: unforeseeable business circumstances, faltering company, and natural disaster. And for certain of these exemptions, some notice is still required. Some states' mini WARN Acts have fewer and or different exceptions than what the Federal WARN Act provides. Different states also have different definitions for what triggers notification obligations, who must be notified, and other significant issues. It is important to consult with an attorney as soon as possible regarding these issues. K&L Gates, for example, would be happy to discuss with you all of the whats you may have. So now that we've discussed the WARN issues, we're now going to return to the pen we left earlier in the podcast and discuss how wage and hour reductions can affect benefits. Employers should consider any new emergency federal, state, or location laws regarding paid time off, leaves of absence, and sick pay. I will briefly touch on some issues wage and hour reductions have on vacation and paid time off, as well as medical benefits. First, vacation and paid time off. In the event of a furlough, employers may allow employees to choose to use sick leave, PTO, or vacation time during this period, provided the employer's policies and applicable state law permit the use of such benefits. If an employee is to remain on payroll, typically he or she is not terminated under state law and would not be due accrued but unused vacation at the time of the notice. However, in some states, like California, even a temporary layoff or furlough may require a company to pay all wages, including any accrued but unused vacation at the time of the notification of the layoff or furlough. Under California guidance, if an employee is laid off without a specific return date within the normal pay period, the wages earned up to and including the layoff date are due at the time of notice. Next, employee health benefits. Employees' health benefits are an important consideration for hour reductions. A reduction of hours, combined with loss of medical coverage, triggers obligations under the Consolidated Omnibus Budget Reconciliation Act, or COBRA. The Department of Labor's website explains that COBRA, quote, gives workers and their families who lose their health benefits the right to choose to continue group health benefits provided by their group health plan for limited periods of time under certain circumstances, such as voluntary or involuntary job loss, reduction in the hours worked, transition between jobs, death, divorce, and other life events. COBRA would not be triggered in connection with a furlough as long as health coverage continues for the employees on layoff and thus are still on the payroll. On the other hand, if health coverage were to terminate for those employees, then COBRA must be offered even if the layoff is only brief or temporary. Most health plans or insurance policies will provide that short leaves of absence, whether or not paid, do not result in the loss of health coverage, in part to avoid triggering COBRA when the employee is expected to return to work. Most plans require that an employee on leave be away from work for at least 30 to 60 days before the health coverage terminates, but that is a matter of plan design. If an employer would like to provide health coverage during a layoff or until a set and specific end date, such as April 30th, which would take the employees through the months of March and April, and the plan does not already require it, it is nonetheless permissible to do so. An amendment to the plan would be required, and the employer would need to obtain permission from the insurer and its stop-loss insurer if it has that coverage. In this case, a company would also need to decide how it would like employees to pay their share of the premiums for the coverage. The company has several options. It can, number one, have employees pay the premiums while on leave. For employees who are on paid leave, the premiums can be deducted from their paychecks in the normal manner. For employees who are on unpaid leave, they could be asked to pay the premiums by sending a check into the plan using their savings or other funds. For unpaid leave, the premiums would be paid on an after-tax basis. This option may be difficult for some employees because they could have difficulty coming up with the premium payments when they are not receiving a regular paycheck. Second option, have employees pay the premiums in advance prior to the leave. Practically speaking, this option may be difficult to implement given the unexpected nature of the layoff. Third option, have employees make up the premiums through additional payroll deductions when they return from leave, provided that applicable wage and hour laws regarding the deductions are followed. Any amendment to the plan would be required by the last day of the plan year, which is often June 30th or December 31st. So for many clients, there is likely time to prepare an amendment if it becomes necessary. Companies would also want to reach out to their insurers as soon as possible if they decide to extend coverage during the layoff to notify them and determine if any policy documentation needs to be updated. If the health coverage is terminated in connection with the layoff, then the normal COBRA 14-day notice period would apply. Finally, if the health coverage is terminated, but the employee is eventually rehired, the Affordable Care Act imposes requirements regarding when the employee's prior plan participation must be taken into account. If an employee is rehired within 13 weeks, the employee must immediately re-enter the plan without being required to satisfy any eligibility requirements. If the employee was gone for more than 13 consecutive weeks, then he or she can be treated as a new hire for purposes of the plan. Well, I hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you so much for joining me. I hope you and your loved ones stay safe and healthy and that you are filled with peace even in this chaotic season.
Thanks again for listening to Working Wise. New episodes are available for download through iTunes, Google Play, and other podcast applications. If you have any topics you would like to hear about on the next Working Wise podcast, please send them to workingwise@klgates.com.